that report, let me now move on to a discussion that would attempt to find, to create stronger cooperation in promoting and protecting the human rights of migrants at European borders. We have with us a number of players, the most important players in the field: the United Nations Commissioner for Refugees, the European Commission, the Office of the High Commissioner on Human Rights, and we try to find how they see the role of the national human rights institutions in this field, how they can support the national human rights institutions, and what is the expected role for us in relation to human rights at borders in view of the current negotiations at the EU level for the new Pact on Asylum and Migration. We are very, very happy to welcome three excellent speakers among us. I would turn to each one of those in turn. I would please ask you to keep your comments within the time allotted. I'm sure that our colleagues at the Secretariat would give all the relevant red flags and whatnot. I turn first to Angela Lee Rossi, who is the Deputy Director of the Regional Bureau for Europe at the UNHCR. Angela, thank you so much. We work very, very closely with the UNHCR, both at the ENNHRI level and at the Greek National Commission for Human Rights. Just this week, we had a series of meetings with the Greek office because we are launching a new initiative very, very quickly. So we would really rely on the fact that you have been outspoken and active in pointing out to European states our obligations under international refugee law at the borders. And we do know that you have very recently released a guidance on engaging with NHRIs globally on those matters. We use that guidance as inspiration in our dealings with governments, with the rest of the players in the field. I wonder whether we can actually have the benefit of your experience and expertise in creating a pathway forward to that respect. The floor is yours. Thank you.
Thank you, Maria, and hello, everybody. Now, I wanted to thank you for giving us the opportunity to engage with you on this. And indeed, as you rightly said, UNHCR has engaged with national human rights institutions not only recently, but I mean, this is part and parcel of our work since, I would assume, since you have created the national mechanism, but also beyond Europe, as you know, in Asia, Africa, and elsewhere. We of course, we recognize the importance of these institutions, not only because of the mandate you have, but also because we think that advocacy and joint action is stronger when you have a group of actors that work together on this, because we each have our different expertise, we each have our different roles to play in that. For example, for us, I think the importance of engaging with you comes, as you rightly said, also from your programs that indeed most of the time include the human rights of persons of concern to UNHCR, so persons in need of international protection, but not only stateless people, we have seen also in Europe. You have a broad advisory function because in support of authorities' commitment to those, because let's not forget, I mean, we're talking about commitments of states to their obligations under human rights treaties, but also under European regional framework. So this has to be put in context, which we're all helping states trying to oblige and abide to those. We also we appreciate the fact that you make public your findings and investigation, and you make very, very specific recommendation to your governments. So the collaboration, as you said, varies from country to country, from continent to continent. We have modalities of implementation with you that go from, institutional modalities with an MOU of an exchange of letters, but also a less formal cooperation. today, I think I would like to, I think you asked us to look at current challenges and current scenarios. I would like to, is it okay? I think you're not talking to me, I hope, Maria. So we have two areas where we think our joint efforts can benefit from an enhanced role. And these two areas are, one is the pushbacks, which I think was mentioned also in the previous presentation. And the other one, indeed, which stems from what's happening at the European external borders, is the concept of an independent border monitoring mechanism, which we have seen also as part of the pact proposal in what they call the screening regulation. So these two areas, I think, are the most important areas in which we can engage together. Now, on the pushbacks, UNHCR considers that monitoring at borders is a key tool for states to actually monitor how they abide to their obligation, but also to ensure that access to asylum is upheld. Because as you know, if you don't have access to territory, access to asylum is rendered meaningless. So access to territory is the first thing that needs to happen when it comes to people in need of international protection. In January 2021, we publicly stated the concern we had on reports of pushback at the European external borders, but also we raised our concern to the fact that those states that we call the frontline states, I'm talking about the sea borders, but not only, because we have also land borders, they sometimes have been left, I wouldn't say alone, because indeed the Commission and the European institutions be very supportive, with money, with tools. But I think we still haven't found the appropriate formula for this support to be tangible, whether it's on mandatory relocation, whether it's on support with capacity on reception and others. So I think we have to put that in context. This does not justify the pushback. This does not justify in any way means what's happening at these borders. UNHCR made this concern very clear. And we actually, as you know, we reiterated that not only you collect evidence, and we do collect evidence together, but there has to be an investigation and prosecution after. Because, if there are investigations and then nothing happens, indeed, the system remains flawed. We value, the opportunities we have also in terms of the challenges and the joint efforts we have on strategic litigation. We have done strategic litigation in Europe since, for many years, I would say. But there have been, I think, recently, there has been more of the strategic litigation at national courts, regional courts, but also at the level of the European Court on Human Rights. And we welcome, of course, that referral, the evidence that have been collected also by the institutions, helping UNHCR and other stakeholders to move this forward. On the independent border monitoring mechanism, I know that, this is, I think, one of the, let's say, the suggestion in the pact, which is the most important in terms of ensuring access to asylum and access to territory, as I said. We called on the presidency, on states to make progress in this regard. As you know, we had regional roundtables with NGOs, but also a joint event with OHCHR. And some of the outcome of this consultation are very clear. The key parameters for such an independent monitoring mechanism have to be, first of all, independence and the operational autonomy and capacity of the monitors, adequate resources. Resources should not be linked to priority of states, but should be linked to priorities of the national human rights institution, and so that they can actually contribute to the independent monitoring mechanism. That doesn't mean that, for example, we have seen that in some states, the national human rights institution have already, let's say, taken that role. In some other states, there's not such a progress in that. And I think we should look at how we can advocate together on establishing such monitoring, independent border monitoring mechanism without creating a parallel system to what already exists in some countries through the national human rights institution and others. So we need to tailor-make this according to the context. And I know that there are differences among our constituency on how this has to look like. What are the modalities? What are the parameters? What role should the monitoring monitors should have. But having said that, I think we need to make sure that the independence of that system is ensured. And I think we count on the human rights institution to make sure that this is discussed with states, that there is a transparency in terms of how we leverage and strengthen the role of each of us. We have actually, I think, submitted some of the proposals both to the Commission and some of the states on what we can do, on how UNHCR can contribute to this. We don't foresee a role for UNHCR, of course, into the systems themselves, but we foresee our role as an advisory role, where we can actually look at the establishment of SOPs, methodologies, the TORs for the monitors, but also the role of not only the national human rights institution, but also the civil society, which we think it's key to make sure that this is not only an independent mechanism, but also a transparent mechanism, so that information is shared and advice is given in this respect. I know that it's not realistic to expect, should such a mechanism be put in place, it's not realistic to expect that this mechanism will be immediately effective and efficient, but we would count indeed on all parties and all constituency to ensure that the mechanism is at least transparent. And what we have noticed, you can have in place a very good mechanism of monitoring human rights violation, etc. The problem is in the implementation of, collecting the evidence, doing investigations, and actually then have, what happens after the investigation. And this is where I think even the, let's say, the infringement procedures that have been used over again by the European Commission have not really led to much of results. I mean, until and unless indeed there was a court decision, and I'm making the example of Hungary, where it took 2 international courts' decisions for Hungary to actually dismantle that infamous center they had at the border with Serbia. So what I'm saying is it's not just a one-way street. There has to be a tool of kits of things that the states and the European institution can use to be able to actually not only monitor it, but actually, have a solution so that states are able, first of all, not to push back because of whatever reason, but also because they have clear obligations under international law and under European law. So we thank you again for having us here, and I look forward to the Q&A session so that we can have a more interactive discussions on that. Thank you.
Thank you so much, Angela. You're absolutely right. Sometimes we do feel alone, we as states. And this is one of the reasons why we have actually launched a number of initiatives trying to come up with groups of people that and create institutional barriers, if you like, and institutional conduits through which we can support the system, safeguard human rights, and make sure that we do not remain alone. This is a joint exercise. This is indeed a European exercise. And I turn to you, Henrik Nielsen, because of course it is the European Union who is the primary actor in that field. We have been talking for quite some time now about the EU Pact on Asylum and Migration. I understand that this is a long process of negotiation that is, I don't know whether it's the beginning or halfway through or the beginning of the beginning, but we do need to have additional information about that. And we also need to know the particular ways in which national human rights institutions can actually get involved and help in that process. So without further ado, I turn to you, Henrik Nielsen, head of the Asylum Unit at the Directorate for Migration and Home Affairs at DG Home, and we're all ears. Thank you.
Thank you very much, and thanks a lot for the invitation and the opportunity to be here and to say a few words to your network. I think you are aware, actually, of the importance that the Commission attaches to both your network and the work of your members. In a broader context, this was recognized, for example, in the Commission's first Rule of Law report of 2020, where the role of national human rights institutions was underlined. In the area of migration, perhaps a few kind of more general remarks to situate it a little bit before we come more to the details. From our point of view, the key message in a sense that guides us is that there can be no contradiction between a strict border management and a full compliance with fundamental rights. Or in a more broader setting, kind of an orderly approach to migration management, again, in full compliance with fundamental rights. That's important to stress, not only from a practical point of view to say that it is doable if all actors do their part and really want to pursue these two objectives, but also to be clear on that it cannot be a discussion about offsetting one objective against the other, which would not lead us to the right aim. More border management would, by definition, lead to less fundamental rights, or more fundamental rights would lead us to less border management. But we really don't want to have that kind of tension. We really need to pursue the two objectives together and in an integrated way. As you know, also, of course, but it's again important to set the context. Our angle from the Commission side is the Charter of Fundamental Rights, meaning that when member states apply EU law, they should also comply with the Charter. So we need that hook from our point of view of EU law being applicable. Largely speaking, that is the case, because if we take together the key we have, for example, the Schengen Borders Code and the Asylum key and the Procedures Directive for the moment, we have that hook in terms of what happens at the borders and how the member states deal with the arrivals, the access to the asylum procedure. So we have that hook to the Charter. This Charter hook is also important to recall a more general obligation before we go into what kind of mechanisms we should have or not have. The more general obligation that flows from the Charter on member states to actually initiate any investigation into any complaint, which is an obligation in itself, which member states need to comply with. It's not a question of what the outcome have to be, because that's an individual case for each investigation, but member states needs to take all allegations seriously, and there needs to be a follow-up mechanism internally. That, in fact, again, applies to the whole migration field. So whatever part of the migration management we are speaking of, whatever allegations there may be of fundamental rights violations, there needs to be a national follow-up. Coming then to the screening and then the monitoring that we proposed in the screening context, again, in kind of the broader picture, what can we do? What do we have at EU level to ensure respect of fundamental rights, and then how can we follow? Well, there is, of course, first of all, the Commission's own powers to be the guardian of the treaties, including with regard to secondary law, infringement procedures, which we use, but which also has its limitations. Europe is big. There is a lot of things happening in the member states along our long borders, so it's not easy for us, to be very honest, to know exactly what is happening at any given moment. We have some case law, I would say a growing case law, that guides us in terms of what we can do and what kind of infringements we can bring. But it's still, I would say personally, an incomplete case law. For example, the evidentiary requirements for the Commission to launch a case against a member state's denial of pushbacks, for example, where is that level exactly? That's something we actually don't know. Infringements are traditionally more focused on issues of interpreting EU law, where it's for the Court of Justice to say, in the end, how do we interpret the law from a legal point of view? The factual side, the evidentiary side, is less obvious. It's not impossible, but it's less obvious as kind of an aim of our infringements. On the more operational side, I think we have in place since a number of years the so-called Schengen Evaluation mechanism, which is how we monitor the more practical application of how member states apply the key, notably in the area of borders, but also beyond visas and other fields. We hope to soon complement that by having a monitoring mechanism also for how member states apply the Asylum key that will be run by the Asylum Agency and based on similar principles. On-site visits, recommendations by the agency on what might be non-compliant, how member states can improve, what best practices can be shared. That brings us then in this context to the screening. So first of all, the reason for the screening proposal, if you like, to put it very simply, is to plug a gap in our current acquis. This period, which is a crucial period upon the absolute first arrival of an irregular migrant and what happens in the next coming days, is in a sense unregulated at EU level today. There is a gap there where basically it's left to the member states to decide exactly what do they do and how they do it. it's a crucial part which we want to fill that gap, to make sure also on this part that we have not necessarily a full harmonization, but EU-level rules on what should member states do, what are their obligations, both in terms of how they should treat the people, but also how they should be processed and their obligations in the prolongation towards other member states. We think it's important to harmonize that, but also again from the perspective of the Charter, to make sure that also in that first crucial phase, member states are applying EU law and hence need to comply also with the Charter. Hence, to continue kind of the reasoning is why we also wanted to single out this part to put a very clear and let's say prescriptive obligation for member states to have a monitoring for this particular phase, the screening phase, which is so crucial in terms of what do you actually do in these first days, and then how do you deal with the people who have crossed your border irregularly. Hence the importance of having a monitoring of that, while again recalling that ideally member states should have national structures in place that covers the whole migration field. But for this particular part, we wanted to single it out and make sure that member states have an obligation to put it in place. It's a bit of a question of an obligation of results. We come here a bit into the limits that we see sometimes at EU level when we want to legislate. It's difficult for us to be overly prescriptive in terms of what kind of administrative structures member states should have in place. For example, we have no EU law, and I don't think we could have in saying that member states should have this kind of asylum authority or migration authority, or their competence should be this. It's similar in the sense that it's difficult for us to say exactly what kind of body or institution should member states have in place to ensure this monitoring. It needs to be a question of results, not exactly saying what to do. We need to respect the fact that member states are different and they will have different structures. At the same time, we don't want to reinvent the wheel. So to be very clear, if member states do have a body in place that has the right mandate, the right resources, the right access to the border, that body can very well be the one indicated by the member state who will take on this role of monitoring in the screening regulation. And that may well be a national human rights institution that already exists and it's already carrying out its work. So it's only in case, let's say, there is nothing. In a sense, I hope not, but let's say there is nothing in a given member state, well, then they will need to create something new or designate an existing body that will carry out this work. And where, to be brief now, I think the principles you have put forward with regard to independence, follow-up recommendations are an excellent basis for what that body needs to do and the mandate that it needs to do. Last point to raise before I run out of time. How can we get closer and how can we cooperate more? We are really open to do that. And I would just encourage you above all to keep feeding us with your reports, both of the network and the national members. It's the kind of things where, it's better, if I put it like this, that we receive it 3 times than 0 times. That we all have information overload and we all struggle to find things which might be available on the internet. So please proactively feed us with that, because we need that kind of report, and I can assure you we look at them very carefully. Second point is to encourage you to engage in the debate at national level. I would see a great scope for your institutions and your members to try to influence the position of your national governments, which they will take in the negotiations in the Council. That's really important to bear in mind this perspective. Not everything has to go through Brussels. It also needs to go through the capitals. And third point, just to encourage you as well to engage with our agencies, because they are in a sense our operational arm. They are the ones who do things in reality, not us, the bureaucrats in the Commission. So Frontex, the Asylum Agency, and of course the Fundamental Rights Agency. Both Frontex and EASO have consultative forums that try to engage with civil society. They are the ones a bit reflecting on how do we answer this key question, how can we design border management which is protection sensitive, fundamental rights compliant, and effective. How to translate that into reality, I know that you can make an important contribution. So just to encourage you to engage closely with the agencies. So I think I'll stop there in terms of the main messages I wanted to have. But indeed, I'm happy to stay on the Q&A session and come back with anything you would like me to do.
Thank you so much, Henrik. I must admit that in your last sentences, you covered my question, which I would have used to launch the Q&A later on, which is really the way in which we need to cooperate with the EU institutions and agents as well, Frontex, EASO, FRA. Their presence, I think, and their involvement is also extremely important in this particular respect. Otherwise, the member states are left out on their own on something that is clearly not a national issue only. It is first and foremost, in my mind at least, a European issue. And I think that there is a balance to be struck there that really needs to be further explored. And that would require initiatives from our part, but also a willingness to engage on the part of EU agencies as well. I would stop that and use that in the Q&A. Ben, I would like to thank you so much for these thoughts. I would now turn to the Office of the High Commissioner on Human Rights, because of course human rights is a very essential element in this very difficult equation. OHCHR has been outspoken about the need for European countries and the EU to ensure that human rights at borders are respected. And they are also involved in this discussion about border monitoring mechanisms at the EU level and the wider range. So I turn to you, Birgit van Hout, the regional representative for Europe at the OHCHR, and we are all ears. Thank you.
Thank you very much, and good morning. Good morning to all of you. I realize we have the most impossible acronym with OHCHR, often also confused with UNHCR. So we're rebranding to UN Human Rights, hoping that might be a bit easier. The strengthening of national human rights protection systems is at the heart of our mandate as the UN Human Rights Office. And that's why I'm very pleased, really, to be with you today to support you in your important role of upholding the dignity and rights of migrants at borders. It's very timely, as we've heard, also in light of the discussions that are going on around the EU Pact. And as you have pointed out, for several years, the international human rights mechanisms and the United Nations, and in particularly the Human Rights Office, have been calling on the EU and its member states to strengthen human rights safeguards and accountability in migration governance. Because the reality is that we have serious concerns, like the denial of entry of rescue boats in European ports, violent pushbacks at the borders, immigration detention, even of children, the externalization of borders, criminalization of solidarity, the lack of systematic access to information, health, and justice, and the overall negative narrative around migration in Europe. While all of these challenges, of course, are distinct, and they are not a topic of today's discussion, I'd like to point out that they are also interlinked. So the first point I would like to make is that it seems important that NHRIs should adopt a holistic approach that addresses the various violations and denials of rights at the borders and beyond at the same time. And such a holistic approach does not only look at violations of human rights, but it also looks at where rights can be improved. And I'm thinking here about the specific protection needs of migrants in vulnerable situations. And you were saying at the beginning of the panel that we were invited to support and share materials that can help NHRIs. And this is one of the publications that we will post in the chat box. We've published a set of principles and guidelines. I'm also thinking about the need to support host communities and to foster social cohesion, to empower migrants and refugees, and remove barriers so that they can and may become full members of our societies. Secondly, NHRIs should clearly articulate what human rights compliant migration governance looks like. While, of course, NHRIs do not adopt legislation or policies, they do influence, as the European Commission has also pointed out, they can influence legislative and policy-making processes. So as such, NHRIs can call on decision makers to adopt a human rights-based approach to migration governance. And what we mean with that is an approach that is premised on the principles of transparency, participation, non-discrimination, legality, and accountability. The human rights-based approach does not only capture the essential principles from the international human rights treaties, but experience also shows that when such an approach is applied, laws and policies tend to be better quality, more effective, and enjoy more legitimacy. And this is the case not only in the area of migration, by the way, but in all the areas. And I'd like to flag a second publication, which is Recommended Principles and Guidelines on Human Rights at International Borders, which can support NHRIs in exactly how to advance a human rights-based approach in very concrete ways. I'd like to mention also the Global Compact for Safe, Orderly, and Regular Migration, because it puts forward what we call a whole of society approach. It encourages broad, multi-stakeholder partnerships to focus on migration in all of its dimensions. And we've heard from previous speakers that NHRIs can build bridges by convening all stakeholders and create platforms for dialogue that include parliamentarians, private sector, civil society, academia, trade unions, and last but not least, the diaspora and migrants themselves. And last year, we had the pleasure together with ENNHRI to advocate for inclusive multi-stakeholder partnerships at the first European regional review of the Global Compact for Migration. Now, such platforms should reach beyond the national level and ensure that also local authorities and host communities are heard, which is currently often not the case. And good coordination between the different levels of government will enhance complementarity and maximize the effectiveness of the various initiatives, and it may also mobilize new resources. Now, moving to EU policy, EU migration policy specifically, we've heard in September the European Commission presented its proposal for an EU pact on migration and asylum, which is currently being discussed by the member states. And we very much welcome the proposal for independent human rights monitoring in the screening regulation. We hope that in the course of the negotiations, it will be preserved. And we would wish that it could be broadened, because the reality is that most human rights violations do not necessarily occur in the course of the screening process. And we've already, Angela has already talked about the joint consultation that we organized earlier this year with international experts, where we really sought to draw some lessons from them on existing monitoring mechanisms and what they felt could be useful for these new mechanisms to be created. And the outcome document, which we also shared in the chat, I'm not going to go into details about recommendations. I mean, Angela already mentioned effective independence is key, as is the need for effective cooperation and information sharing with existing monitoring bodies like NHRIs, the CPT, the treaty bodies, the UN Special Rapporteurs, the SRSG of the Council of Europe for Migration and Refugees, the Fundamental Rights Officer of Frontex, and civil society. I mean, look at how many different actors that we have in the field with a monitoring role. And it would be vital that the new national monitoring mechanisms that are created, that they complement existing capacity rather than cause fragmentation and duplication. And so we welcome also the fact that the Commission in its proposal invites member states to invite national, international, and non-governmental organizations to participate in the monitoring by the national monitoring mechanism. As some of you may know, last week our office published the reports on search and rescue and the protection of migrants in the central Mediterranean, which is called Lethal Disregard, and we will also post this report in the chat box. Our High Commissioner, Michelle Bachelet, has urged EU member states to show solidarity to ensure that frontline countries are not left to shoulder a disproportionate responsibility. And in the report, we also recommended that national human rights institutions and other monitoring bodies be allowed to visit all locations, including search and rescue vessels, disembarkation points, and places of detention to interview migrants. Indeed, under the optional protocol to the UN Convention Against Torture, some national human rights institutions act as national preventive mechanisms. We should not forget this. And this is unique in many ways. It is the only exclusively preventative international human rights treaty and the first human rights instrument that entrusts national bodies, namely the national preventive mechanisms, with a role in the implementation of an international human rights treaty. Now, I would like to also spend a few moments on the role of national human rights institutions in monitoring the rights of migrants beyond and to go beyond monitoring. NHRIs should be able to effectively investigate all allegations of human rights violations based either on complaints or on their own initiative. But their expertise should also be leveraged to ensure that national laws, policies, and practices, as well as bilateral, regional, and international cooperation agreements and arrangements, do not have a detrimental effect on the human rights of migrants. NHRIs can also undertake awareness-raising activities like campaigns on human rights education or human rights education to counter harmful narratives on migration by focusing on what we have in common and the future we share rather than what makes us different. And in this regard, what we can offer to you a toolbox on migration narrative change that we have developed to support workshops and initiatives around positive narratives. We've piloted some social media clips ourselves using this toolbox in Polish, French, and Spanish. And by the way, it was the Polish NHRI that facilitated our cooperation with a grassroots organization in Poland, which created a wonderful video for the campaign. NHRIs are, of course, also have a natural role or well-placed to train law enforcement, border guards, and other authorities on their obligations towards migrants and refugees. Now, I understand that all of this is a daunting task. And again, I would like to echo what previous speakers have said, that under the Paris Principles, states must provide NHRIs with sufficient resources to carry out their mandate. Another requirement of the Paris Principles is the cooperation of NHRIs with international human rights bodies. And I would just like to take a moment to highlight how precious the reports from NHRIs are as sources of information for the human rights assessments by the treaty bodies, the special procedures, and the Universal Periodic Review of the Human Rights Council. And it is no coincidence that the UN Human Rights Council and the General Assembly regularly emphasize the importance of NHRIs. And we would like to echo the call on the EU for a similar privileged relationship with NHRIs. The EU Action Plan on Human Rights and Democracy can serve as an example. It commits the EU to supporting NHRIs outside the EU that comply with the Paris Principles. Similarly, I would really like to encourage the EU to stand up for NHRIs within the EU with the same commitment. And likewise, as you have said, all EU agencies working on migration, Frontex, EASO, FRA, EU-LISA, Europol, should be called upon to foster interaction and to invite and engage NHRIs. To give only one example, information from NHRIs could be very useful in informing Frontex due diligence policy, which is mandated under Article 46 of EU Regulation 2019/1896, which is commonly referred to as the Frontex Regulation. I would like to close in conclusion by saying that monitoring is not a goal in itself, but it's a means to an end. So both NHRIs, as well as the national monitoring mechanisms to be established under the pact, under the proposed pact, should play a key role in instilling a human rights culture in border management entities, as well as in national and local authorities more broadly, so that human rights are not perceived as an obstacle to border governance, but as living values that serve the common interest. Thank you very much.
Thank you very much, Birgit. And I thank you in particular because you highlighted some of the issues that we consider very dear and close to our hearts, simply, and we're working already on that. I'm particularly pleased to hear about the human rights compliance approach. The Greek National Commission for Human Rights has already published a status report, which is really a human rights impact assessment of the situation regarding migratory and refugee flows. And we are regularly updating that major report. The first issue, I think, has been already on your desks for quite some months now. Thank you. Yes, so there you are. And we are going to have more and more information coming your way on that as we also build our own institutional responses to this kind of thing. Thank you all for your contributions. And there are issues that need to be explored further on, implementation of the ECJ's decisions, for instance, but I'm sure that we're going to discuss them once again. Angela, Birgit, Henrik, thank you all for your contributions. And this is, ladies and gentlemen, this is going to be a very brief break just to renew your coffee mugs, and we're coming back for the next session. Thank you so much.